Boston police officer John O'Keefe was found lifeless beneath a blanket of snow outside of 34 Fairview Road in Canton, Massachusetts on January 29, 2022. A discovery that ignited a storm of mystery and accusation. His girlfriend Karen Reed is accused of second-degree murder, with prosecutors alleging she struck O'Keefe with her Lexus after a night of drinking and arguing. Yet the case is anything but straightforward. O'Keefe's body bore injuries some experts say don't align with a car strike. Defense attorneys claim he was assaulted inside the home of Brian Albert, a fellow Boston police officer, during a gathering shrouded in silence. They allege a cover-up, citing missing phone data, altered timelines, and conflicting witness accounts. Crucially, though, taillight fragments were allegedly found on John O'Keefe's clothing, evidence the prosecution calls compelling, linking John O'Keefe's dead body to Karen Reed's SUV. But no surveillance footage has surfaced. No clear narrative has emerged. What really happened that icy night remains cloaked in uncertainty as the trial unfolds and the search for truth grips a divided community. Tonight, we are live from the courthouse with all the big moments from another big day in the retrial of the century. I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments, and we are getting closer and closer to the end of this trial, the Karen Reed retrial of the century. You know, anyone who's been accused of a crime or arrested has a right that is very unique to our system, the right to remain silent. So powerful, the foundation of our system of justice. The burden is always on the prosecution. A defendant never has to say anything. They don't have to prove their innocence. It's the prosecution, the state, the Commonwealth, the government who has to prove that you did it and prove it beyond any and all reasonable doubt. Now, that right to remain silent is a big moment in every trial, right? When a defendant has to decide whether or not they're going to testify. And we have a history of hundreds and hundreds and hundreds of trials here at Court TV and hundreds of high-profile cases at Court TV. And I've got a couple of guys who did not remain silent at their criminal case. Both were murder cases. Kyle Rittenhouse, who was charged with murder out in Wisconsin during the Kenosha riots. He exercised his right to testify. He did not remain silent. He told his story to the jury. And the jury believed him, and he was set free by that jury. That was out in Wisconsin. Down in the low country of South Carolina, Alec Murdaugh, a disgraced attorney accused of murdering his wife and son, also chose to testify, did not remain silent, told his story to the jury, and they weren't buying it. He was convicted, and he is now serving his life sentence and desperately trying to appeal all of his many, many convictions. So it can go either way, right? It can go either way. And maybe it's based upon the truth. Maybe Kyle Rittenhouse didn't murder anyone. Maybe it was self-defense. That's what the jury said. Maybe Alec Murdaugh did murder his wife and son, and that's why they didn't believe him when he testified. So, you know, these are the decisions that every criminal defendant has to make. Karen Reed has not remained silent. Now, she hasn't testified in court, but she has spoken openly about what happened that night, not to me necessarily, but to other members of the media. She speaks outside of the courthouse just about every day. She also has done sit-down interviews talking about what happened that night with different media outlets. And a lot of those interviews that she did, clips of them have been put in front of this jury by the prosecution. They believe Karen Reed telling her story, they believe she's incriminating herself with those statements, and they're trying to use them against her. Like we say, you have the right to remain silent. What you say can and will be used against you, and that's what's happening to Karen Reed in this trial. What she has said publicly to the media, certain select pieces that the prosecution has taken from her many interviews have been put up on those huge screens inside the courtroom and shown to this jury. So that brings us to this moment as the trial begins to wind down, the defense getting close to the end of their case. The question we ask every time, will she or won't she testify? Will she remain silent or not remain silent? Will she tell her story first person, eye to eye, tell it right to the jury? Or is she going to exercise her constitutional right to say nothing and leave it up to the state to try to prove beyond a reasonable doubt every element of every crime she's been charged with? Well, let's get an answer to that question. Court TV crime and justice correspondent Matt Johnson is live outside the courthouse in Dedham, and he's been trying to get this answer for weeks, perhaps months. Have you gotten the answer today, Matt Johnson?
We got the answer today, Vinny, and it's one that rattled the courthouse here. It surprised a lot of people, especially members of the media, because as you've been saying, this defendant has been very outspoken from trial 1 in 2024 to the retrial that brings us here today. And she has also done all of those sit-down interviews, those clips, part of this trial, played to this jury. And I can tell you, I'm in court, as you were when you were visiting for the week, and this jury is very fascinated anytime they play those clips in the court. So outside the courthouse earlier today, she told me this. Take a listen. Are you going to testify?
I'm not testifying.
Why make that decision?
The case is it's our last witness. The case will be over by...
But the jury has heard your interview clips?
They have heard my interview clips. They've heard my voice. They've heard a lot of me.
All right, so she says that she is not going to take the stand. Up till now, her answer has been TBD. She's not going to testify, but she is ready for the verdict, she says.
So TBD has turned into an NO. There we go. Matt Johnson,
correct.
I mean, you've been asking, and you got the answer. Nobody else was asking. Nobody else was asking it's like the most important question. Matt was. All right, let's talk about some of the arguments this morning about the dog bite testimony.
Yeah, so this was Alan Jackson. He was fired up outside the presence of the jury. The jury was outside of the courtroom for quite a while today, as he was really arguing over what he wanted with his expert, with the pathologist, Dr. Elizabeth Laposata, and he wanted her to be able to testify in the scope and talk about the injuries to Officer John O'Keefe's arm and be able to opine that it could have been from a dog attack. Take a listen.
I'm not going to allow Dr. Laposata to testify regarding dog bites. Your rights are saved. I'm going to give an instruction regarding burden shifting. So.
I think it's outrageous. I think the conduct is outrageous. And I don't think that a curative instruction can do anything except bring the point home again.
Okay.
But if the court is not willing to allow her to testify to her full opinion to a reasonable degree of scientific certainty, can she at least testify that she reviewed the arm, looked at the arm, that it's consistent with an animal? Can we at least split the baby?
I will do that. I'll allow that. Yes.
Okay, so that was a big win for the defense right there, with Alan Jackson asking that of the judge, Beverly Cannoni, to at least meet him halfway. So Dr. Laposata, once the jury was brought in, was able to say her opinion, not saying dog, but she was able to say animal, and that the injuries happened before Officer John O'Keefe died. Take a listen.
So I can determine that they were inflicted prior to death.
Do you have an opinion as to whether or not the wounds that you see, the patterned injury that you see on Mr. O'Keefe's right arm, is consistent with an animal bite or claw marks?
Yes, it is, very much.
Okay, again, that was a huge win for the defense, as they're trying to say, you know, that Officer John O'Keefe was attacked by an animal and then placed out on the lawn, is their theory. That's going to be put forth again on their closing argument, which could be this week, Vinny.
Yeah, you know, I say it every time. The defense says 2 weeks, and it means, you know, 3 days. And we had a day off last week. Things are moving. There's a lot of legal argument in between that slowed things down a little bit. But yeah, I can see the light at the end of the tunnel. Matt, at some point, you're going to have to move from Massachusetts back home. at some point. Not yet, though. Not yet. Wait till the jury's done.
Okay.
All right, let's talk about Dr. Laposata again. She provided a lot of interesting testimony in some different areas. You mentioned the animal scratches or bites. How about hypothermia? What did she have to say about that?
Yeah, a lot of arguments over that because you remember the state medical examiner testified. That's Irene Scortibello. She took the stand and she said that the cause of death for the victim in all of this, Officer John O'Keefe, was blunt force injuries to the head and then hypothermia set in, and then he later succumbed to those injuries. Well, Laposata's opinion was blunt force trauma with a raised rough object that he fell on, not a flat surface, and not hypothermia. She was challenged on that on cross, though. Let's listen to both.
Do you agree with or concur with the blunt force head injury as a cause of death?
Yes, Mr. O'Keefe died from the blunt force head injury.
Do you concur with the diagnosis of hypothermia?
No, the body did not have any hypothermia.
Could somebody be alive, outside, in the cold, below 32 degrees, not moving, covered by snow, still alive, and lose body temperature?
Sure.
And then could they, after an hour, 2 hours, could they then die and continue to lose more body temperature?
Sure. Anything's possible. It's just what's important is what happened in this case.
I'm asking for your medical opinion, though, rather than to be an advocate.
So again, when you're looking at the two competing theories here that the jury is ultimately going to have to figure out, when we're talking about hypothermia, it's whether or not his body was moved, right? It comes down to that. And then for the blunt force injuries, did he hit a flat surface, which could have been the front yard if it was just cold out and frozen, or did he hit an object, or was he hit or struck by an object? Those are two major competing theories here that this jury hopefully can figure out.
Yes, I think everyone wants the jury to figure it out this time and come to an agreement, all 12, on all 3 counts. Or if it's not 3 counts, let the judge know that they reached a verdict on at least one of the counts. You know, let's hope that happens this time. Okay, let's talk about ARCA again. We had a second ARCA witness. This one, expertise a little different.
Yeah, and we have seen ARCA on the stand quite a bit. And I know that it feels like that for our viewers, but keep in mind, last year was trial 1. That was a separate jury. This year is trial 2, completely different case. And then also all of the voir dire when they were brought into court without a jury. So Dr. Wolf, they took in mind and considered very different things. Dr. Wolf, his job was to analyze the vehicle damage. He testified first. Now on the stand is Dr. Rentschler, who is focusing on body injuries and if they're consistent with a vehicle crash. He just started his testimony. Let's listen to what he said today in court.
So as to the question of whether Mr. O'Keefe suffered the occipital skull fracture as a result of being hit by the tail lamp at 15 miles an hour, were you able to scientifically rule that out?
I was, yes, sir.
Was that to a reasonable degree of scientific certainty?
It was, yes.
Did you reach any opinions or conclusions regarding the abrasions on the right arm that you noted earlier on Mr. O'Keefe's body?
Yes, I believe my conclusions with respect to the abrasions are that it was inconsistent with contact to the tail light, and that not only that those injuries are inconsistent, but you would expect additional injuries, likely fractures to the hand and or the forearm, depending on the actual speed of the vehicle.
So that's really just the beginning of his testimony when we're talking about direct examination and, of course, cross. Whoa, it's going to be heated. But it really goes, again, to the defense theory about possibly an animal or a dog attack, right? Because you have Dr. Russell, the dog bite expert, that said that that's her opinion in those injuries. Then you had this pathologist saying basically the same thing, that it was an animal, not saying dog. And then you have this witness saying that it wasn't from a car. So those are all back-to-back for this defense team so far.
And I understand what they're doing, and you combine that with the fact that Karen Reed's not going to testify, that they want to finish with the experts and let the experts tell the story. because there is no eyewitness. And if the defendant doesn't testify, then this is what the jury will be left with. A big battle of the experts. Matt Johnson in Dedham. Looks like it's getting cold again. You got the jacket on. What's going on? It's June, for goodness sake. Okay.
A little bit of rain today.
Little rain,
but we
okay.
managed.
All right, Matt, we'll be seeing a lot of you as we get ready for this case to wind up. Let's bring in our Karen Reed insiders to help us tonight. Criminal defense attorney Joseph Krowski Jr., Kevin Lenahan, YouTuber, author of the book Storm of Suspicion, the Karen Reed Trials, along with Karen Reed supporter and insider Nick Rocco. All right, we're waiting for one more, but we'll get him when he comes in. So to me, the big headline is Karen Reed saying, I'm not testifying. I know everyone's going to say, I'm not surprised. I know every attorney's going to say, no chance she was going to testify. But what I saw differently here, and I'll start with you, Nick, is that these specifically chosen clips of Karen Reed, anyone I've talked to, whether they know the case or don't know the case, no one thinks that they make Karen Reed look good. There's a reason why the prosecutor has chosen to play these very select clips of Karen Reed. Do you think that this jury actually knows who Karen Reed is? You obviously have spent more time getting to know Karen Reed. Do you think the jury is getting an accurate portrayal of Karen Reed through these clips that were played in court?
No, I don't think the prosecution wants them to accurately portray who Karen Reed is as a person, and hence why those videos are taken out of context. But at the end of the day, no matter what she's saying in those clips, you have these defense witnesses, experts that are on the stand that are just proving the Commonwealth's case didn't happen, and John O'Keefe was not struck by a vehicle. Those videos I think are going to come into play at a certain point in the deliberation, but I don't think much is going to be given to it by the jury after what they're hearing this past week.
Joseph Krowski Jr., experienced criminal defense attorney. You have to make this decision or advise your clients on this decision all the time. I'm just going to take a guess. You tell, or you advise, you don't tell, you advise most of your clients not to testify.
Sure, that's a conventional wisdom in most cases. However, I have noticed, a trend over the last couple of years of defense attorneys willing to advise their client to get up and take the stand, even though jurors are advised that they can't consider defendant's failure to testify against them, it can't draw an adverse inference. I have to believe that if you were to ask jurors to truth tell, they do want to hear from the defendants. And the problem in this case is there was a voluntary decision to go out and try this case in the media. And they gifted the Commonwealth with a lot of ammunition. And Karen Reed herself promised that they were going to put those videos into context. That's why I assumed that her testifying was a live issue. So I was a little surprised today. It's probably the right decision given the state of the evidence and given those admissions and confessions, but I was left a little bit surprised.
Kevin Lenahan, obviously the decision is always difficult, but it's always, what's going to happen on cross-examination. From your perspective, what are the vulnerabilities or the potential vulnerabilities of Karen Reed if she had decided to take the witness stand?
Well, her story has evolved, you might say changed a lot over time. Also, the way they've chosen to try this in the public. And I'd be curious as to how Nick feels. She and her team have been sending him out for over a year to put things out into the public about John going in the house and 227 and this and that. And now the defense team has completely abandoned all of that. And all they're going to go with is reasonable doubt here. They didn't put up a single data expert to talk about going up and down stairs or 227. How does he feel personally, knowing that they've been exploiting him in this way and putting him out, and now they're not presenting any of this to the jury? I'd just be curious to how he feels about that.
Nick, I got to let you respond.
I don't even have words for that, to be honest. They're putting me out there. You're acting like
no question
I'm
about
doing
that.
It's
You're in the
at this
limo with
point,
them.
I don't have an answer for that because what he's accusing me of is just not true. but the defense still truly believes what they stand behind in the first trial. It's just that Judge Beverly Cannoni and they're up with a different battle with Hank Brennan, who obviously didn't call these specific witnesses because he wants to handle them on cross-examination, which, you know what, it might be a smart choice by Hank Brennan. But at the end of the day, the prosecution is supposed to bring out the truth, whether it hurts or is in favor of them. And by not calling them, it was obviously for only one reason, and it was to have the defense call them so then Hank Brennan gets on cross-examination to try to rehabilitate them all. And that was his plan. So the defense didn't lean into it because there is another road to go. You can have two situations where John went in that house and got beat up in the house, and also police misconduct in this case. So you can have it both ways, and they have both avenues to go down, except Judge Bev won't allow one specific way without an uphill battle, unfortunately.
All right, folks, stand by. Our insiders are staying with us. When we come back, we'll take a closer look at Dr. Laposata's Opinions Plus coming up next hour. Tonight on Vinnie Politan Investigates, the retrial of the century includes evidence of alleged confessions, expert testimony, and physical forensic evidence. Prosecutors say taillight fragments were found on John O'Keefe's clothing. Is that true? Tonight, we investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, tonight, 9/8 Central, only on Court TV.
Karen Reed is in the midst of the retrial of the century.
She is factually innocent. She's guilty.
There's something wrong in this county. Come at me.
The Karen Reed murder retrial. Live coverage weekday mornings, 8/7 Central, on Court TV.
When you were doing differential diagnosis, did you look at any information that would tell you what the speed of that impact may have been or allegedly was?
Well, it didn't hit him, so it doesn't matter.
Dr. Laposata, the forensic pathologist testifying for Karen Reed and the defense, very confident in her testimony, very experienced in her testimony, very comfortable on the witness stand. It was very interesting to watch. Take a look at more of her testimony, and obviously the cross-examination is really the most important, right? You know what they're going to say on direct, but it's the cross-examination. Does her testimony and her credibility withstand the attack of Hank Brennan? Let's take a look.
So you didn't care to know anything about the car or the data in the car because you had already formed your opinion?
It did not hit him, so it was not relevant to my opinion.
Is that a different way?
By looking at the body, I could tell that there was no evidence of impact with a vehicle. So whether the vehicle was going slow or fast is not relevant.
I told you, she was confident. Let's bring back in our Karen Reed insiders, Joseph Krowski Jr., Kevin Lenahan, Nick Rocco, and yes, here he is, folks. Give him a standing O. Massachusetts criminal defense attorney Peter Ellikin. All right, Peter, I'll start with you. Even though you came last, let's what we just saw there, the back and forth. I don't know if you've ever had her in a case of yours or not, but is she winning that battle? Because this could be devastating to the prosecution if she wins this.
Yes, he certainly, as you said, certainly speaks with confidence and certainty. Absolutely rule out a vehicle strike. She says if the vehicle had actually, hit his arm, there would be tissue, bruising, crushed tissue. There were no bones broken or fractures anywhere in the hand or arm, that it wasn't consistent with plastic. The wounds were not consistent with the plastic hitting it. And so she really, but however, I'm jumping ahead now. I'm always looking at the big picture here, and I'm trying to, project myself into what the jury's thinking now. And they hear her saying absolutely not a vehicle strike. And then they heard the prosecution's experts say, not a dog bite, it's a vehicle strike. And again, I don't know that if the prosecution hasn't just overwhelmingly won over the jury on this, then again, it's like they cancel each other out, reasonable doubt under the best case scenario for the prosecution. So what does the jury do when they hear two, let's say for the sake of argument, two good, credible experts, and they have totally 100% different opinions? And where does the jury go with that?
Scorty Bello, though, wasn't so definitive in her opinion for the prosecution, Joseph. What are your thoughts here about this particular battle of the woman who did the autopsy, the doctor who did the autopsy, and the doctor who's coming in here after the fact?
So, you know, I know Dr. Laposata, and I really hope she's not watching tonight. Because I'm going to be a little bit, I'm going to be a little bit critical of her here. There was some similarities between her and Buchanan. Look, juries are sophisticated, and they know when a witness will not concede simple points that they are cloaked with bias and they have an agenda. It doesn't take a medical expert to know that, of course, the speed of the car, the position of the impact, all kinds of other information, including debris field, statements of the defendant, matter when you're forming an opinion. And the jury's going to be instructed that experts don't speak in irrefutable truths. They're only allowed to give an opinion to assist the jury. And again, Dr. Laposata here spoke in absolute truth and wouldn't even concede simple points. If you want to look at the silver lining for the Commonwealth, there is no evidence at all that was opined by Dr. Laposata that John O'Keefe was involved in a fight, and in fact bolstered the periorbital ecchymosis, which is a product of the brain injury from falling down and suffering a blunt force trauma to the back of the head. So I don't think she was effective as Karen Reed supporters might think.
Let's take a listen to the doctor talking about hypothermia.
No, the body did not have any hypothermia.
What led you to that conclusion?
Well, when you have we know that normal body temperature is around 98, and we know that then at the hospital that Mr. O'Keefe's rectal temperature was around 80. So we know that his temperature went down. So there are two ways the body temperature can get down. It can get down while you're alive, or a dead body also cools when it's in a cold environment. So those are the two things you have to look at. Wisniewski's ulcers, which are diagnostic of death due to exposure to the cold. So these areas are little tiny craters, and they fill up with blood. And we see that in over 90% of the cases of people who die from exposure to the cold. This is the Mr. O'Keefe's stomach, which has been opened up when we're looking at the inside. There's no ulcerations here. So the diagnosis of death due to hypothermia is not appropriate in his case.
Do you have an opinion as to a reasonable degree of medical certainty as to whether Mr. O'Keefe suffered from hypothermia?
I do have an opinion.
What is that opinion?
He did not experience hypothermia.
Did you observe any signs of frostbite?
No.
Did that have any weight concerning your opinion, overall opinion, as to whether or not Mr. O'Keefe died with complications associated with hypothermia?
Well, if someone dies due to exposure to low temperatures, you expect to see not only the Wisniewski's ulcers, but you expect to see some frostbite changes in the extremities.
All right, Nick Rocco, give me some context here. Why is this important to the defense, that there's no hypothermia, no frostbite?
Well, the significance of that is he had to have died in a warmer place other than outside, because if what the Commonwealth is claiming, he was outside at 12:32, was lying in the snow and slowly died, he would have at least had signs of some type of frostbite on his extremities, as the doctor had said. And you don't see any of that. And then once you get into the autopsy and the stomach lining, he has no signs of the ulcers inside of his stomach lining. And those are the telltale signs of someone being outside in a cold place for more than 20 to 30 minutes at a time. So that alone right there, the fact that the jury was able to see what a stomach looks like with hypothermia and one without it, and John's was completely different, I think that registered with them. Well, if he couldn't have had a hypothermia, then he had to have been somewhere where he wasn't as cold.
Kevin Lenahan, your thoughts on that?
So it's interesting that neither the state's theory about what happened or the defense's theory about what happened really matches up very well with her testimony. She was very confident that John would have died 15 or 20 minutes after sustaining the injuries. That doesn't really match up with any idea of her being in the house or being outside the house. So the paramedics showed up at the scene at little after 6 a.m. You think these trained emergency responders couldn't tell if someone had been dead for 5 or 6 hours? It doesn't make sense at all. So, and it was clear out of the gate. So Hank Brennan came out and said, "Good afternoon." And she corrected him and said, "It's not going to be afternoon until 6 minutes from now." So she was combative right out of the gate. So she came across as somebody that was clearly competent, as you would expect with someone with her experience, but someone that was extremely biased and was all bought in on every part of the defense theory and just trying to help the defendant. And I don't think the jury was going to miss that.
All right, insiders, stay with us. We've got more to get to. Some heated arguments from both sides, and I'm talking about the lawyers. That's next.
Now what we have is we have holes in the back of the sweatshirt that were dramatically held up to and confronted with Dr. Wolf, and then the jury sees it. With the clear, unmistakable, purposeful intention of having the jury conclude that these holes could have come from events on January 29th of 2022, when in fact the Commonwealth well knows from its own documents, from its own criminal list, that those holes in the back were caused by their criminal list as part of their examination and sampling of the hoodie. What could be more egregious? What could be more misleading?
It's so intense inside that courtroom. And then he's got the black gloves on as he's delivering this argument to the judge, holding up the papers, calling out Brennan for misleading the jury about a crucial piece of evidence. That was yesterday. And then today, again, the temperature turned up inside that courtroom, which doesn't have air conditioning. Take a listen.
The Commonwealth cannot have it both ways. They cannot walk up and say and leave the impression with the jurors that Dr. Laposata opined about the dog wounds, but we're not able to hear it. We, the jurors, are not able to hear it because obviously that is something that is her opinion, whatever it might be, is harmful to the defense. When in truth and in fact, it's exactly the opposite. Dr. Laposata's opinion has never wavered. Those injuries on John O'Keefe's arm are from a dog, period, full stop. Anything less than presenting that to the jury at this point would be to perpetrate an intentional fraud on this jury.
The pattern of conduct that stands out is persistent, repetitive, contrary to court rulings and court orders, and deliberate. And that is, the defense uses their witnesses to vouch for their own credibility. They use their witnesses to introduce information they know is not admissible, and they use their witnesses to introduce otherwise inadmissible hearsay. Dr. Laposata was voir dired briefly. She did not provide qualifications that she has a history of education or training on pattern wound recognition analysis as it pertains to dog bites. We asked her questions about her specific experience. She did not provide a basis, and so her opinions regarding dog bites should not be permitted in this trial.
Mr. Brennan literally just said, I didn't elicit any information about dog bites. I just asked about her experience. Question by Mr. Brennan.
That's not what I said. That is
Excuse me.
No, I'm not going to.
So I heard what Mr. Brennan said. You don't need to tell me what Mr. Brennan said, but go ahead to your argument.
How about if I quote his words? How about that? He elicited the information suggesting that Dr. Laposata was being hidden from Dr. Russell because her opinion would harm the defense. He left that with her on purpose, then turned around and 3 days later said, and by the way, the defense should be disallowed from using Dr. Laposata to talk about the very dog bite wounds that I asked Dr. Russell about. That cannot stand as a scorecard.
Go ahead.
It's helpful if you read the entire thing in context, which I won't do. We always have a right to object to an inadmissible opinion. So the suggestion that somehow an ambush here is not only misplaced, it's strategic by the defense to try to create a narrative. It's improper.
Is it just me, or in the last couple of days have things gotten a little bit more intense as we get close to the end here? Joseph, what's going on here?
Oh, I love it. You know, it's a small, tight courtroom. They're all getting sick of one another. This has been a really hard-fought, well-tried case. So these things happen all the time. I don't think they take it personally at all. And look, there's some showmanship going on here, too. You might remember when the autopsy photo was shown and the defense mistakenly labeled it as including Trooper Proctor being present at the autopsy. He wasn't. There was a picture put up when they were examining Dr. Russell, and they had dog bites written right on the picture. So things happen. This case has thousands and thousands of pages of discovery. So I don't think anything is intentional. This is zealous advocacy. I invite it and I enjoy watching it, to tell you the truth.
But this is all in front of the judge, right?
Go ahead.
You're not putting on a show for the jury. This is in front of the judge. It just seems like it's getting personal, Peter.
Yeah, I would say that, you know, by all accounts, people inside that courtroom were saying that for all these weeks, these guys were getting along. It was collegial atmosphere. They were all old buddies. And obviously, Brennan is a criminal defense himself, the attorney himself, just doing this one-off prosecution. So they're all kind of in the same family. But it's not unusual that in a very, very lengthy and complicated trial that suddenly the tensions are up towards the end and people get upset. And certainly it does seem like it's getting very personal. It's not just somebody made an error, the other side made a mistake, but it's strategic. It's intentional misconduct. It's egregious. And so it is getting very personal. Not unusual in a high profile, lengthy trial though.
Kevin, and Peter makes a great point here. The allegations really are going from both sides that the other side is doing this stuff on purpose. At the end of the day, what is your take of it? As you're watching this, are you watching lawyers doing their job, or are you watching people kind of like putting their heart and souls out there and making this into a personal battle? I don't want to lose.
So I think you got to go by if you're trying to decide if somebody lied on purpose or did something like that on purpose, you have to look and see if they knew that it was likely to be discovered shortly after that, then they probably didn't do it on purpose because nobody wants to be embarrassed that way. There was a moment like that earlier in one of the hearings where Hank misspoke about information between the feds and who had revealed it, and it was corrected 15 minutes later. And everybody was like, he lied on purpose. But he clearly didn't, because he knew it was going to be corrected just 15 minutes later. So the judge has already ruled on this, that it was not on purpose, and this was not going to be the result was not going to be a mistrial. There was a way they could cure this with the jury.
Now, Nick, the other part of this, and when it happened yesterday, the moment where Hank Brennan was misleading the jury about a piece of evidence, the alleged holes from being run over in the back of his sweatshirt, which were just cutouts from the criminalist. I saw that happen, and Nick, I'm thinking, this is going to, you know, it's so similar to last year when you had the inverse video, and then suddenly the government as a whole, right, is looked at by the public, by the Karen Reed supporters as, oh yeah, here they go again. Here they go. Is there a perception that Hank Brennan is part of this now with some people in the Free Karen Reed camp, the Free Karen Reed supporters?
So I personally don't believe Hank Brennan is involved in what has happened over the past 2 years. But as far as him holding up that sweatshirt, whether it was intentional or not, it just allows the public to lose more faith in the justice system, in the sense of, well, this prosecutor's trying to put away Karen Reed for the rest of her life, and he's telling the jury false information, whether he knew it or not. He should know the case like the back of his hand. If he thinks there's enough evidence to have Karen Reed found guilty, he should be able to go into this trial and know exactly everything that he stands behind. And in this situation, yes, you can compare it to the inverted video. Ultimately, you get caught and then you have to own up to it. And Hank Brennan did get on the stand and own up to it. But one thing I just wanted to say, as far as the heated moments in the courtroom, When the cameras are off and court is done for the day, I will say I think this is, maybe for some of them it's personal, but at the end of the day, it's a job. And there are smiles between Hank Brennan and the defense team and vice versa. But when it's on, it's almost like a boxing fight. When you fight, it's on. After the match, you shake hands, good fight. And I think that's what we're seeing. The end of the trial's coming. Everyone's fed up with everybody. I think everyone's ready for a verdict at this point.
You guys all love each other, though. That's why we bring you guys together all the time. Joseph, I have one more question, and I'm curious. Will the defense be able to attack the credibility of the state's case and the voice of the state, Hank Brennan, in their closing argument by referencing what Hank Brennan did in showing them the holes in that shirt, or is that over the line, not permitted to do that?
Over the line, and remember, the Commonwealth gets to go last, and that opens the door for them to go after the defense for the opening, all the promises they made, for completely injecting Proctor throughout the trial, not calling him, for putting him at the autopsy when he really wasn't there. So look, things happened. There was no intentional misleading. Jackson didn't even pick up on it on redirect. So it's a bygone.
All right, get ready, guys. I'm going to need you every night next week as this jury is deliberating, so don't make any plans. Joseph Krowski Jr., Peter Elkin, Kevin Lenihan, Nick Rocco, thank you so much. When we come back, I will reveal something else you need to know tonight, plus coming up next hour. Tonight on Vinnie Politan Investigates, the retrial of the century is wrapping up, and two key witnesses from the first trial have not been called. Brian Albert and Brian Higgins. Why not? Tonight, we investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on Court TV.
Daybell, doomsday cult mom, convicted killer, and now defendant, and yet another high-profile trial. Will this be the final chapter in the saga
of the doomsday cult mom? The Lloyd Daybell conspiracy trial, mornings on Court TV.
Time to reveal something else you need to know tonight. Let's take a look at the big board and objection. You think you had a rough day? How about Lori Daybell and her trial, trying to examine a witness and listening to a whole bunch of objections from the prosecutor? Let's take a look.
And did she advise you in that interview of some business deals that Brandon was involved in?
The objection's sustained. It's hearsay.
The defense would move to publish the email?
State would object. We're going to go into that.
We already discussed this exhibit. I'll sustain the objection. It's not being entered into evidence.
Your Honor, I'm going to object to hearsay and relevance.
I'm not asking for the truth of the matter. I just want to know what he knows.
I didn't ask for argument. You can show him the document and then rephrase your...
Not in any report that I read. In a report that you read?
I object to testifying
Sustained.
and asked and answered and argumentative.
That's the objection sustained.
But she came to you because were you aware that Brandon had not returned the children to her?
It's sustained as to relevance.
Have any for her, is that correct?
Relevance.
Sustained.
And that, ladies and gentlemen, is why you should exercise your right to have an attorney represent you in a court of law. We'll keep an eye on that case is wrapping up this week as well. Right now, though, I need you to take a look at your television screens. We have a missing child who needs your help. This is Corina Rivera, missing from Snellville, Georgia since May 27th, just 15 years old. If you see Corina, please pick up the phone, make a call, make a difference. 911, 1-800-THE-LOST, or you can call the Snellville Police Department in Georgia. That number's on your screen right now. Let's see if we can get Corina to a safe place tonight. Don't go anywhere. We have another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.